Good afternoon, ladies and gentlemen, and distinguished guests. I have been serving as a judge of the extraordinary chambers in the courts of Cambodia, the ECCC, or commonly known as Khmer Rouge trials, for 6 years. And I tendered a letter of resignation to the United Nations Secretary General on 16th of May, and today is in fact my last working day as a judge. My resignation will take effect on the day after tomorrow. So on this opportunity, I would like to brief you on the major developments in recent years and months, and some challenges and prospects for the future, and also what I understand the court has so far achieved through the judicial process. First, I'd like to draw your attention to some of the handouts which you have. Could you first take a look at the color printed the court report? This is a special court report in February, which report the Supreme Court Chamber's issuance of the final appeal judgment on case 001. Case 001 regards this individual, Mr. Ken Gek Eve, better known as alias Duke, who was deputy director and then director of so-called S21 Security Center in Phnom Penh. And he was prosecuted for crimes against humanity and war crimes, and more concretely for killing more than 12,000 of inmates in the S21 Security Center. The trial chamber convicted him in 2010 and sentenced 35 years imprisonment. And both prosecution and the accused, and in fact the civil parties as well, appealed to the trial chamber's judgment, and the case was put before the Supreme Court chamber. This final judgment by the Supreme Court chamber was issued on 3rd of February, and this marked the first final conviction in the history of the ECCC. If you could take a look at the following pages, this report describes some of the initial reactions from victims and Cambodian people, as well as local and international observers. This is the first case, and for the moment there are some more cases in the dock of the court. The second case, commonly called case 002, is for four individuals who are believed to be so-called senior leaders of the Democratic Kampuchea. And one of these four individuals has been separated from the other three individuals for her own status of her mental condition. So for the moment, there are only three accused facing the trials before the trial chamber. These individuals are all pretty famous and believed to be senior leaders of the regime, next to the head of the regime, Pol Pot. They are Mr. Kyu Sam Fan, Nuon Chia, and Ian Sally. The fourth individual I mentioned earlier is Mrs. Ian Thillis, who is wife of Ian Sally. This second case has been ongoing since last October or so, and the prospect is that it will take some more time to see a concrete or tangible outcome from this case. The case one was limited to crimes committed in S21 Security Center. However, this case 002 includes a lot of different crime sites spread over the entire Cambodian geographic regions, and include crimes against humanity, war crimes, and genocide. They have been prosecuted for numerous counts, and the trial chamber has tentatively separated the entire case 2 into three so-called segments. Currently, the trial chamber is hearing the cases regarding the segment 1, which mainly concerns forced deportation of city people residing in Phnom Penh in the early part of the Khmer Rouge regime. However, because of the advanced age of the accused individuals and challenging financial status of the court, there has been an increasing concern that the criminal procedures before this tribunal is really a race against time, and the trial chamber is now seemingly making best efforts to expedite the proceedings as long as they can comply with the recognized international standards of due process and fair trial rights. There are two more cases so-called case 003 and 4, and these cases are still under the investigation stage. There seems to be 5 individuals for these case 003 and 4, and the case is with the co-investigating judges at present. It has been reported that there is a considerable difference of views between the national co-investigating judge and the international co-investigating judge as to how to proceed with these 2 cases. And during the last year or so, the tribunal has provided the media with a lot of news in relation to the abrupt resignation of 2 consecutive international co-investigating judges, or reserve co-investigating judges. For the moment, these cases are yet to be decided as to whether it will be prosecuted or not, or whether it will be finally put before the trials or not. So in sum, during the last 6 years, since the tribunal has started its activities, so far the court has concluded the case 1 by the final conviction in February this year, and the major cases for 3 individuals who are allegedly senior leaders of the regime is at the trial stage, and 2 more cases are under the investigation stages. If we take a look at the next handout, the ECCC financial outlook, you could imagine how costly these criminal procedures are. Even if this tribunal is known as hybrid court, which is a mixture of national and international characteristics rather than purely international characteristics, it still costs very much in comparison with normal domestic trials. The chart, the first chart indicate that during the last three or so years, the court averagely cost around $30 million per year. And this estimate is increasing for the next 2 years, including this year, which will cost around $45 million. Then the second chart shows how this huge amount of money has been covered. The fundamental structure of the financing for this court is a voluntary contribution, as well as the Cambodian government, financial and other input to the court. At the bottom of this chart, on the right side, shows the total contribution from all the donors, including the host country Cambodia, so far is around 160 million US dollars. And Japan has been on the top of the donors in terms of the amount of contribution, marking 47% or 75 or 76 US million dollars so far. Other major donors include Australia, Germany, United States, France, United Kingdom, and of course Cambodia, etc. When this court has started these criminal proceedings, there was a rough estimate that the entire proceedings would be completed roughly during 3 years. And in fact, that was what I heard of when I applied for the job. But we can now say that 6 years has elapsed, and we are still in the middle, or maybe even before that. And that, of course, means that the donors' estimate for the total amount of necessary contribution has to be greatly reviewed. In fact, the Japanese government, when it contributed 21.5 million US dollars in the beginning of the trials, thought that it was the first and last contribution if the then estimate of 3 years completion would be realized. But the chart shows that $21.5 million was only the first part of the Japanese government's contribution so far, and that applies similarly to all other donors. So at present there are on one hand the frank and from our side what we are grateful for the appreciation by the Cambodian and international communities for the achievement of the court so far. And on the other hand, there is a growing concern that a race against time is becoming even more severe, and the court has to expedite its proceedings as much as possible. However, as you may imagine, criminal proceedings are often very slow in the eyes of the general public, and especially when the case is severely contested by the accused, as is the case with this case too. So despite of the ongoing best efforts by the trial chamber, it seems that there is no magical way to very quickly reach the completion of the case 2, even regarding the first segment of case 2. If I may explain my own understanding as to what the court has so far achieved, I would say perhaps 3 or 4 points. First, of course, we have issued the final conviction to one individual, and that marked the first ever event in which individual criminal responsibility was made clear concerning crimes committed during these 4 years. During the last 3 and more decades, nothing has been done in this regard except the 1979's death sentences for 2 individuals, Pol Pot and Yen Sali, by the People's Revolutionary Court, of which death sentence was never executed. So this is commonly described as a fight against the culture of impunity. Even through one case, I trust that the court has sent out a strong message that these crimes have to be punished and will be punished. However, time has elapsed. The second aspect of my recognition is that through that criminal proceedings to reach the criminal conviction, the historical records has been established to some extent. To some extent. I mean that the main job for any criminal trials is not to write a history, but in exceptional cases like this, for example, where there has been no official records to be commonly shared by the community of people, the limited activities of the criminal trials to adjudicate criminal prosecution could to some extent contribute to that aspect. Of course, that court's establishment of relevant facts is limited to what is necessary for the court to reach that legal decision. However, in the absence of credible and official records in general, I believe that the trial chamber's establishment of relevant facts means something to the people of Cambodia. Thirdly, that might pave a way for the Cambodian people's own efforts for national reconciliation. The Cambodian government, from the top officials of the government, we have repeatedly heard that they expect that the outcome of these criminal proceedings would somehow contribute to the enhancement of the national reconciliation. And again, to enhance the national reconciliation is not the direct outcome of the criminal proceedings, or not the initial mandate of any criminal trials, but in the context of these tribunals, and in relation to my first and second points, I trust that the court activities so far has contributed somehow to this aspect by paving a way for the Cambodian people to start discussing these tragic pasts. And this can be done not only by the final judgment of case 1, but also by entire court activities, which includes a very wide range of outreach activities being conducted by the public affairs section or victim support section. They are making best efforts under the limited financial resources or human resources to spread the relevant information to the Cambodian people and society, and this literally covers every corner of the Cambodian country. Through this process, it has been gradually known better by the people of Cambodia that this court is going on, and this court is making best effort to bring justice for the people of Cambodia after several decades of absence. However, I would have to say that from this point on, there are perhaps not much that foreigners could do. This is a starting point for the Cambodian people to initiate their own discussions, and hopefully involving a younger generation who have been mostly excluded from the knowledge relevant to this regime. Recent movement shows that the Ministry of Education has included the description of the Khmer Rouge regime in the textbook for students. And this is one of the positive signs that Cambodian people who tended to keep silent on what happened during these years have gradually but steadily changed their attitudes and started openly discuss about this tragic past. And that is, of course, the initial step for preventing these tragedies from occurring again. Lastly, these tribunals' activities perhaps could contribute to some extent to the capacity building of national judicial sector. My colleagues, my Cambodian colleagues in this court are also working in the Cambodian judiciary as leaders, current leaders or future leaders, and what they have shared with us, the United Nations judicial officers, would without doubt help them to enhance their compliance with internationally recognized standards of due process and fair trial rights. And this was again emphasized by the highest level of the Cambodian government as one of the hopeful side effects of the tribunal's activities. If we also take a slightly different aspect on the activities of these tribunals, I would perhaps also add that some of the legal contributions to the field of international criminal justice could also be mentioned. In particular, this is the first international or hybrid court in which the victims' participation and reparations were introduced as a major part of the proceedings. Together with the International Criminal Court, ICC, these are at present only two tribunals in this field which addresses the victims' participation and reparations in a fundamental way. This aspect was very challenging for us too, and I have heard also frustration or dissatisfaction from some of the civil parties who participated in the proceedings, or their reaction to the final decision of the court in terms of reparations. However, I would say that the court did its best to accommodate the victims' justice as long as the legal systems allows us to do it. And this is still the very early stage of thinking and implementing the mechanisms, and I would expect that the lessons learned from this tribunal would be utilized by other tribunals, in particular by the International Criminal Court. So this is my brief explanation as to the current status and major challenges and what is seemingly the outcome of these 6 years operation of the tribunal. And I'd open the floor to you for comments and questions, ladies and gentlemen. Thank you very much.